Thank you, Your Honor. Good morning. First, I want to thank you for your service. You had a chance to meet the people on our team, but I also want to thank them for their help. You may remember Ms. Alexander and Mr. Forrester, who will be helping me. And I don't know if you met Keith, but you should meet Keith because he will be one of the most important people in the courtroom. He's making sure this mic works, stuff goes up on the screen, and I want to thank him. And I don't know if you met Louis. Would you mind standing up? Louis is our legal assistant, and he makes sure everything gets to the courtroom and everything like that. Thank you for your help. And then they're blocked a little bit by the little drawings I'm going to do here, but could you please stand up? This is Neil Luria, the plaintiff, and sorry, here, Gonzalo Dorta and Orali Herrera.
Good morning.
Who would see them? I'm going to say thank you to them. I'm going to prove to you that the defendant, Pricewaterhouse, didn't do their job. I'm going to prove to you that the defendant, Pricewaterhouse, was grossly negligent. The evidence will show that year after year after year, for 7 years, Pricewaterhouse signed their name to an audit report certifying over $4.6 billion in fake assets. And I'm going to prove to you that the defendant's gross negligence, it mattered. The evidence will show that when the defendant, Pricewaterhouse, didn't do their job, the third largest bank failure in American history happened. The evidence will show that when the defendant, Pricewaterhouse, didn't do their job, thousands of people lost their jobs overnight. And the evidence will show that when the...
Sustain.
Excuse me, Your Honor. And the evidence will show that when the defendant, Pricewaterhouse, didn't do their job, a fraud grew from just a few $1 million to a $21 billion fraud.
Overruled.
But I'm going to prove to you more than that. This is a punitive damage case. And I'm going to prove to you that the defendant was not just grossly negligent, but engaged in intentional misconduct.
Sure.
Ladies and gentlemen, and other things, from time to time, the lawyers and I might need to discuss something over here. That's called a sidebar, and we apologize. We're trying to keep those down to a minimum, but sometimes we have to make a legal decision at that moment. So that's what we were doing.
Thank you again, Your Honor.
Okay?
As I was saying, the evidence will show that the defendant, Pricewaterhouse, intentionally provided intentionally provided their audit report that certified $4.6 billion in fake sales to the plaintiff. I'm going to prove to you that the defendant, Pricewaterhouse, didn't do its job. I'm going to prove to you that Pricewaterhouse's job mattered, and that when Pricewaterhouse didn't do their job, over $1 billion was lost by the plaintiff. Now, for y'all to understand all this, I'm going to have to explain to you who everyone is and what happened. And to do that, I'm going to outline what the evidence will show in this courtroom, what you're going to hear from witnesses, what you're going to sometimes see from witnesses on that big screen like we're at the drive-in, and what you're going to see from the actual documents in this case. Okay? So the first thing I'm going to prove to you, I'm just going to write one thing here, that PricewaterhouseCoopers, who we're going to call PwC sometimes, PricewaterhouseCoopers, PwC, had a job. Pricewaterhouse's job was to be certified public accountants doing audits. And to understand what an audit is, you need to understand just what they were auditing. They were auditing a public company, a bank called Colonial Bank. And to do their audit, PricewaterhouseCoopers, the evidence will show, was required to gather evidence of whether Colonial Bank's financial statements were materially misstated, whether they were true, caused by error or fraud. In this case, the evidence will show that Colonial Bank's financial statements were misstated due to fraud. So let's start first with what's a financial statement. A financial statement is a box. No. A financial statement is when a company writes down on numbers on a piece of paper what it's got and what it owes. So what it's got is called assets. And that might be cash, might be buildings they own, and that would be what a company would write down. We got $100 million worth of cash in buildings. That would be their assets. The other thing they would write down is their liabilities. And that would be what they owe. And that would be, right, or loans they had to pay back. That'd be stuff they owe. That's a financial statement. Now, for companies, those can be big numbers, right? For a bank, they're supposed to have money because they're a bank, right? So what an audit does is an audit goes in and gathers evidence to determine whether or not what they got and what they owe is not materially, meaning misstated by amount that matters. Okay, not materially misstated. Now this job that Pricewaterhouse had, auditing a public company, the evidence will show, is really important. Because for a public company, the evidence will show that people are counting on Pricewaterhouse to do their job. And one of the ways we know that is it's right in Pricewaterhouse's own documents. When Pricewaterhouse does an audit, they're required to write down what they do. It's called their work papers. And what they write down is the official record of the work they performed. And what I'm going to show you now is the financial statement that they were auditing and then what their official record said they did. Okay. Put that in. Yeah, let's start with the front page. So this is the front page of the financial statement of Colonial Bank, one for the 7 years they did it, one each year. And because it's a public company, Colonial had to file their financial statements with the United States Securities and Exchange Commission. And that means they're on a website available to anybody in the public that wants to look at them 24 hours a day, 365 days a year. And if you turn in this statement online, you see that on the first page, right before the numbers, those financial statements we were talking about, on the cover page goes, can we go to that page, Keith? Goes the report of independent registered public accounting firm. And then they literally sign their name, Pricewaterhouse. And if we pull out there the first paragraph, Keith, just as an aside, as the judge will instruct you, y'all get to have all these documents, okay, if they come into evidence. And what does Pricewaterhouse sign their name to? They say that in our opinion, the consolidated financial statements, what they got and what they owe, present fairly in all material respects the financial position of Colonial Bancorp and its subsidiaries. So that's what Pricewaterhouse signs its names to. That the financial statements present fairly in all material respects. And if we turn to the very next page, we see the first page of those financial statements. And if you see there the assets and liabilities, what you got and what you owe, the evidence will show that Pricewaterhouse statement that the financial statements presented fairly was false. If you look at the numbers over there, yeah, can you pull that out, Keith? There. Supposed to have was these securities purchased under agreements to resell. This is stuff they've got. These are actually mortgages. And if you look at the top there, see where it says in thousands? Can you highlight that for us, Keith?
That means for all these numbers, you add 3 zeros. So see there where it looks like it says 1,500,000? That's actually 1 billion. 1.5 billion. The evidence will show that almost all of that, a little under, just under 1.5 billion, didn't exist. The evidence will show that what Pricewaterhouse signed their name to, that these presented fairly the financial position, was false. Now, the job that Pricewaterhouse did was not just important because this was filed publicly. The evidence will show that Pricewaterhouse understood what its job was at the time. Go to number 3. This is part of those own documents of Pricewaterhouse. See their name right down there in the bottom? And this is for Colonial Bank. And Pricewaterhouse is saying, what is the objective of their audit? Where they go in and gather evidence to say whether those numbers are materially present fairly in their words. And Pricewaterhouse said, we're doing this, our audits, our objective is for shareholders of Colonial Bank, because it's a public company, the evidence will show they were public shareholders, but also for other stakeholders. Because why? Pricewaterhouse said, we're supposed to be independent when we do our audit, objective. And if we sign our name, our audit reports add credibility to the financial information released by Colonial to the marketplace. So when Pricewaterhouse signed its name, it knew that its objective was to add credibility to those numbers. The evidence will show that PricewaterhouseCoopers is one of the largest auditing firms in the world, and it was justified for people to rely upon such information because Pricewaterhouse said so. Our name adds credibility. So if we look at how this works, you have Colonial, you have Colonial Bank, and Colonial Bank has financial statements. That's F/S if you can't tell. And as we just saw, those numbers up on the screen, and the evidence will show that the law says that before these financial statements, yes, those are the financial statements, and before they can be released to the marketplace, they cannot go out to the public until certified public accounting auditing firm, Pricewaterhouse, the defendant, signs their name to that audit report and says they're fairly stated. The evidence will show that Pricewaterhouse is known as the gatekeeper because Pricewaterhouse can only sign, only after Pricewaterhouse signs can the financial statements go from this side to the marketplace. And the evidence will show, in this case, that Pricewaterhouse knew that one of those stakeholders, it was their audit objective was to add credibility for those stakeholders. One of those stakeholders was TBW. The plaintiff trust as bringing the claim of Taylor, Bean, and Whitaker. And one of the ways that the evidence is going to show, and I'm going to prove to you, that the defendant, PricewaterhouseCoopers, knew that one of the stakeholders was TBW, is that the corporate representative of PricewaterhouseCoopers, Mr. Gary Westbrook, he was the partner in charge of these audits. And he will testify that he knew that a potential stakeholder of his audits, his own audit objective, was TBW. So in doing, go ahead. Yes. So in doing these audits, to add credibility to Colonial's financial statements that the evidence will show Pricewaterhouse knew was being delivered to the marketplace, including TBW, the plaintiff, what exactly was their job? The evidence will show that their job, the evidence will show that Pricewaterhouse's job was to provide reasonable assurance that those financial statements, can we put those up, Keith? That those financial statements were not materially misstated due to error or fraud. The ones with this one had a 1.5, is off by 1.5 billion. And the first way I'm going to prove to you that that was their job is that that's what their own document, their own contract says. Now there were 7 audits. So Pricewaterhouse signed its name for 2002, 2003, 2004, all the way through 2008. I'm not going to show you 7 letters. I'm going to show you one. Right? And what does Pricewaterhouse say they're going to do? We will design our audits to obtain reasonable, but not absolute, assurance of doing what? Detecting errors or fraud. Now, when Pricewaterhouse has an opportunity to speak to you, and again, as always, please give them the same attention you're giving me. Understand they're going to tell you that they just considered fraud. They just thought about it. We will prove to you, and the evidence will show, that it's just what they said. Their job is to obtain reasonable, not absolute assurance of detecting errors or fraud. Now, I want to focus here not just on detecting errors or fraud that have a material effect on the financial statements. If they make a mistake and they're off by a few $100s in a great big bank like this, that's not what we're talking about, okay? Because it has to be material, it has to be important. And we will prove to you that billions and billions of dollars, the financial statements being off by billions, is material. But also, see where it says reasonable but not absolute assurance? It can't be just what Pricewaterhouse thinks that day. The evidence will show that it must be reasonable, that the rules they have to follow require that they have evidence called evidential matter to back up when they sign their name. And it's not absolute though. Okay? Reasonable assurance is a high level of assurance, the evidence will show, but it's not absolute. So I may say this more than once. I'll try not to be repetitive, Your Honors, listening. Pricewaterhouse is not a guarantor. They're not given an absolute assurance. And if you find, after hearing all the evidence here, that Pricewaterhouse followed the rules they were supposed to follow every year for 7 years, and they just miss these giant errors caused by fraud, then you should rule for them. But if you find, as the facts are in this case, that year after year after year, Pricewaterhouse didn't do their job, they did not follow the rules, and they failed to detect this fraud and sign their name to fake assets, then we're going to ask you to rule for plaintiff. So hold them to this standard, reasonable assurance. And the rules tell us that reasonable assurance is a high level of assurance. This is part of the rules that they have to follow. There's a rules called from the Public Company Accounting Oversight Board. They set the rules along with Journal Accepting Auditing Standards. You're going to get to learn all these neat phrases. But basically, these are the rules they have to follow when they do their audits. And this rule says, although not absolute assurance, reasonable assurance is nevertheless a high level of assurance. And that's the standard they're held to. But it's not just their own engagement letters that says it's their job to detect fraud. The Public Company Oversight Board, yes, also talks about what? An auditor's overall approach to do what? The detection of fraud. Because guess what? If you have to say whether the financial statements are reasonably sure, a high level of assurance that there's no misstatement due to error or fraud, part of your job is detection of fraud. And that's exactly what it says. It says the auditor should therefore assess risks and apply procedures directed specifically to the detection of material fraudulent misstatements of the financial statements. This is the organization that governs them, the Public Company Oversight Board, and it says, direct your procedure. So what we have in this case, as the evidence has shown us, we have a public company called Colonial Bank. Its auditors are PricewaterhouseCoopers. Pricewaterhouse's job is to give this high level of assurance of detecting fraud, that the financial statements are not materially misstated due to fraud. And who is the evidence showing they're delivering this to? To the public, to the stakeholders in the marketplace by their own words, and that includes plaintiff TBW. So PwC had a job detect fraud. And the second thing I'm going to prove to you is that PwC failed to do its job. Now, the first way that the evidence will show that Pricewaterhouse, PwC, failed to do its job is when it was doing these audits year after year after year. Part of what it was supposed to do was look at these billions of dollars in transactions. And the rules required them, and in fact, their own rules required them to look at the contracts that govern these transactions, because they have to gather evidence. And the evidence will show. You should put it up. She's shaking her head at me. No, not that one. I'm sorry. And the rules that tell them about fraud actually say, look out. Fraud is usually concealed and management intent is difficult to determine. So the rules that told them about fraud actually warned PricewaterhouseCoopers, this evidence tells us, that look out. Guess what? If someone's committing a fraud, they might try to conceal it. And it says certain conditions may suggest to the auditor that the possibility is a bit of a roadmap. You know, if you go in and look at a company and there might be a fraud, here's some things to look for. And what's the very first thing the rule says? Well, an important contract may be missing. The evidence will show in this case that there were over $1.5 billion in fake sales, but no contract. So instead of there being a contract and review it and look at it and see if it, there wasn't even a contract. Transactions were supposedly going back and forth, billions of dollars. No contract existed. So I'm going to prove to you that PwC, Pricewaterhouse, failed to do its job. And the first way I'm going to prove it is there is a missing contract for the very transactions that were fraudulent. So if we look in the financial statements, now we've moved back a couple of years, we're from 06 to 07. And the evidence will show that for these securities purchased, this big asset that Colonial supposedly had, that for the first 2 years, there was no contract even in existence. And the evidence will also show that even after there was a contract, Pricewaterhouse never requested and examined the actual final written contract, not the entire time. And during that period, if you can see in 2006, remember that's in thousands, so that's 605 million, almost all of which did not exist. The evidence will show that by failing to examine the contract and make sure that this was real, the fraud grew from 605 million to 2007. Actually, 1.5 of that is not real. It didn't exist. So the fraud more than doubled between 2006 and 2007. $4.6 billion in total in fake sales under these contracts that they never reviewed. And that's what the evidence will show. Now, to understand this a little better, I need to give you some more about what the evidence is going to show about who's who and who did what. We're going to do that over there. I'm going to come here now. Your Honor, I think you can still see the board. Okay. It's what we call a multimedia presentation. Now we're going to use these. So we have the defendant, PricewaterhouseCoopers. And PricewaterhouseCoopers is auditing those financial statements of Colonial Bank. And Colonial is doing business with TBW, Taylor, Bean, and Whitaker. And the evidences show Colonial Bank is a public company filing its audit reports publicly. Colonial Bank is a bank and they have money. Taylor, Bean and Whitaker is a mortgage company. And as a mortgage company, what Taylor, Bean and Whitaker's job was to originate mortgages for people's homes. So a mortgage is just a loan on somebody's home. So if you get a car loan, a loan to buy a car, that's called a car loan. If you get a loan to buy a house, right, that's called a mortgage. So TBW was issuing mortgages to people. But TBW was not a bank, and the evidence will show to get money to originate these mortgages, they went to Colonial Bank. And the evidence will show that the largest customer of Colonial Bank was TBW. So how did this start? Well, in 1999, Colonial Bank started its mortgage warehouse lending unit. And they brought in a woman by the name of Kathy Kissick to start their mortgage warehouse lending. Kathy Kissick wanted to grow that business. She wanted mortgage warehouse lending to be a successful part of Colonial Bank. And she needed, it's Catherine Kissick, and she needed customers and businesses to do so. Ms. Kissick needed someone who needed her. And she found that someone at Taylor, Bean and Whitaker by its chairman, by a gentleman by the name of Lee Farkas. And the evidence will show that over the course of the next, starting 9 or 10 years, Taylor, Bean and Whitaker paid to Colonial Bank almost $1 billion in fees. The evidence will show that Kathy Kissick turned mortgage warehouse lending to be the biggest and most profitable part of Colonial Bank. And the evidence will show that to grow this business at Colonial Bank, Ms. Kissick had a problem. You see, the evidence shows that there are federal caps on how much money a bank can lend to any one customer. And those are to keep banks safe so that banks don't get overextended. So there was a limit of how much business Colonial Bank could do with TBW, and therefore there was a limit on how much fees TBW could pay to Colonial Bank. To get around that federal limit, Kathy Kissick looked to come up with an idea called true sales. So instead of loaning money to TBW, they had the idea that they would say they were actually sales. That what she was doing was she was buying the mortgages back rather than lending the money. So when the money would go here, instead of it being a loan, the idea was that Colonial Bank would buy the mortgage. And that would allow them to get around these federal caps. So instead of doing just in those terms, a couple of $100 million worth of business, this allowed them to do billions of dollars in business and make more and more fees. But more specifically, an accounting fraud. Because these mortgages for billions of dollars didn't exist. They didn't exist. So these transactions were fake sales. So to do this accounting fraud, the evidence will show that Colonial, Ms. Kissick, and Mr. Farkas, what are now convicted felons, they needed the gross negligence of an accountant. And the evidence will show that accountant was the defendant, Pricewaterhouse. In 2002, to get around these caps, Ms. Kissick went to Pricewaterhouse because the government needed an opinion from a certified public accountant that it was okay to do this as sales instead of loans. And this piece of paper, Matt, this piece of paper in which a partner for Pricewaterhouse, Mr. Jackson, signed to permit sale treatment, the evidence will show that Pricewaterhouse was grossly negligent when they signed this piece of paper. And this one piece of paper allowed Ms. Kissick and Mr. Farkas to take what was just a small few $1 million and grow it into an over $21 billion fraud. I'm going to prove to you that Pricewaterhouse failed to do its job. I'm going to prove to you because when they were looking at this transaction with these mortgages that didn't exist, they approved it with a missing contract. I'm going to prove to you that they approved it by breaking the rules and not looking to see whether the mortgages actually existed. Let me put that up. The next work paper. So Pricewaterhouse, again, remember their own official record, their work papers? Their own official record actually talked about what they were supposed to do. And that work paper said, we're supposed to identify and examine the collateral held. And the collateral, sorry to walk back and forth, the collateral, that's these mortgages. And Pricewaterhouse's work paper, the evidence will show, is correct. That was what Pricewaterhouse was supposed to do. They were supposed to examine, identify the collateral held. We're doing fields? Yeah. And if you look at the next page of what they wrote down, they wrote, we're going to count the collateral to verify the existence. But the evidence will show, what do you see? In procedures, it's blank. Even though their own work paper said count the collateral, Pricewaterhouse didn't do anything. Instead, they wrote, they thought there was a low risk of real estate mortgages. That's not highlighted, but it's there at the top. A low risk. And what do they say about these transactions we're looking at? They're called AOT and Colby, so you'll see AOT and Colby, that's those transactions we're talking about. It says PwC feels that this collateral for these securities purchased under agreement to resell, that's that big number, is adequate. They feel? The evidence will show a feeling is not evidence. And the evidence is going to show that a feeling is not the high level of assurance that reasonable assurance is supposed to give. But that's not all. Because we can look and see who did this. Can we do that? And if we pull out who actually did this work, we can see it was completed by Alicia L. Whetstone. Ms. Whetstone was not a certified public accountant. Ms. Whetstone was an intern. she was auditing billions in transactions. Now, Ms. Whetstone, she needed supervision because she's an intern. And the evidence will show that it was Mr. Westbrook's job to make sure she got that supervision. But the person supervising her is right on their document, Philip Rivers. And Mr. Rivers will testify before you that this transaction was, quote, above his pay grade. I'm going to prove to you that PwC failed to do its job because feeling is not evidence. But there's more. Because the next year, Pricewaterhouse actually did assign certified public accountants to do this job, to look at these same transactions. And again, Pricewaterhouse got it right. Their job was to identify and examine the collateral. Look at those mortgages and pools of mortgages. They wrote it. That's what they were going to do. They even said in our procedures, we're going to do this. But what were the results? What did they actually do? Can we put that up, Keith? It's the same paragraph from the year before. It's what the intern wrote. If you look from year to year, it's the box from year to year, the evidence will show that Pricewaterhouse just cut and pasted from one year to the next. I'm going to prove to you that PwC failed to do their job. I should have wrote and. Because cut and paste is not evidence. And if we look back at that financial statement, when it grew, the non-existent assets grew from $600 million to, I think it was $1.5 billion. Can we do that, Keith? That's the 2 years we just looked at. So in 2006, when the intern wrote, "We just feels," and she wasn't supervised by anyone, or someone who was above their pay grade, it was almost $605 million non-existent. The next year, when PricewaterhouseCoopers cut and pasted, the fraud grew by $1.5 billion. But there's more. Sorry to keep moving around on you. Coming this way now. Thank you. Because it turns out that the rules were just like what was in PricewaterhouseCoopers' work paper about counting. The rules actually say when something has a physical existence, you should look at it and examine it to find out whether it's real or fake. Can we put that up, Keith? So the rules, here you can see faded at the top, this is evidential matter. Remember I told you they have to get evidence? The rule says the independent auditor's direct personal knowledge obtained through physical examination. That's what an auditor can do. And if something is physically available for the auditor, like a mortgage, then they can actually come and look at it. Do we have that rule? Assets having a physical existence are available to the auditor for his or her inspection. So the evidence will show it's like, if you want to know if I want to know if that screen's behind me, I can look at it, I can examine it. And mortgages have a physical existence. When you have to sign for a mortgage, that house loan, you have to sign all these documents, including the note. And I know in these days we email stuff and everything's on our iPhone, but the rule still is In that world, you have to have physical paper, what they call the blue ink signature. It's an actual something you can hold and examine. And the evidence will show that Colonial job was to be the custodian, to hold on to these mortgages. So when money went, remember it's supposed to be a sale, mortgages are supposed to go back, and the mortgages are supposed to be sitting in Colonial Bank. And not just anywhere, they actually have a vault, like you keep money in. And they had vaults, 2 vaults, that these mortgages, or when they were pools, these participation certificates are supposed to be sitting in the vault. Now the evidence will show that this was in Orlando, Florida. And every year, Pricewaterhouse would go to Orlando to do their audit, and that vault, one of them was just in the basement. And in the basement, Pricewaterhouse, to determine whether or not these mortgages were real or fake, thank you, Anthony, you could just push B on the elevator. Just push B. Go downstairs, go in the vault, take the list, and look and see if the mortgages are there that match the list. The evidence will show that the criminals never created fake documents of mortgages. The evidence will show that the vault for the mortgages that were fake just weren't there. Just press B. The evidence will show that there was actually a list of mortgages. And those mortgages came page after page of what the mortgages were supposed to be. Now, around page 22 or so, for the next, 25 pages, the mortgages started being followed by a B. And the evidence will show that all of those mortgages didn't exist. They were just on the list. But they weren't in the vault. And the evidence will show that PricewaterhouseCoopers, to find this fraud, just need to press B and take the list and look in the vault. Because if they'd have found just one, no mortgage, this fraud would have been done. I'm going to prove to you that PwC failed to do its job because just to compare to the vault. Now, I'm going to prove to you more than that. I'm going to prove to you, I'm sorry, I'm going back and forth. I can tell you, I'm only going to write like 1 word or 2 words at a time, and I'll say them out loud. I'm not going to do any more drawing or anything like that on those boards.
Thank you.
You're welcome. Because here, right, you have Miss Kissick, she's a fraudster working at Colonial Bank. There's another one, there's 2 fraudsters, Miss Kissick and Teresa Kelly, okay? Working with them at TBW are 6 fraudsters, okay, including their owner. Remember we talked about Lee Farkas. Those people have all been put in jail. So when I say that's who they are, they've been convicted and put in jail, okay? Everyone pled guilty, the evidence will show. Miss Kissick was facing 30 years, and she pled guilty and testified, and she still got 8. And Mr. Farkas, he's the only one who went to trial, and Mr. Farkas was convicted at trial, and he got 30 years what Ms. Kissick would have gotten. Now, to understand here, you should know that Mr. Farkas, he was the chairman and majority owner of TBW. And when Ms. Kissick was looking for someone who could help her, she found the right person. Desiree Brown was the treasurer. Richard Allen, Ray Bowman were directors. Delton DeArmas and Sean Ragland. Okay? They were committing a fraud. Going to be undisputed here, they were committing a fraud. Okay? One of the things that we understand you're going to hear is, well, this fraud was collusive, and we follow the rules, but we just didn't find it. I believe that's what defendants are going to say. What I'm proving to you, and I believe the evidence will show, that there was nothing about what these fraudsters were doing that caused Pricewaterhouse to not just look at the contract when the contract didn't even exist. There was nothing that these fraudsters did that prevented Pricewaterhouse from actually going and trying to count the collateral and just write it feels. The fraudsters did not cut and paste from one year to another without doing the work. That's what Pricewaterhouse did. And there was no fraudster standing at the vault preventing Pricewaterhouse from getting in, and the fraudsters didn't create fake mortgages. They just weren't in there. And that's what I'm proving to you. And the rules themselves actually say and warn Pricewaterhouse of exactly what we're talking about. The rules themselves say management employees engaged in fraud will take rules actually say it may be concealed from collusion. Watch out. And the rules actually say that there may be third-party false confirmations, which we're going to get to in a minute about how Pricewaterhouse just sent an email to Mr. Farkas to ask him if this transaction was real instead of counting the collateral. So the rules actually warned Pricewaterhouse. And I told you I was going to say this a couple of times. Here's the second time. You see there where it says properly performed audit? If you determine that Pricewaterhouse properly performed their audit, they followed all the rules, and somehow year after year after year after year after year after year after year, they just somehow missed this, then you should rule for them. But if you find that Pricewaterhouse did not do their job and did not follow the rules, then we will ask you to rule for plaintiffs. So here we have all these failures, and the other thing we have is Deloitte and Touche, who is auditing TBW. Deloitte and Touche is TBW's auditors. And if we look, can we go back to the criminals? If you will see, there are two criminals at Colonial, but it doesn't include Colonial's chairman, any of their directors, or anything like that, okay? It includes two people in the mortgage warehouse lending unit. It's different at TBW. See, it's the chairman, treasurer, board of directors here. And as a result, Pricewaterhouse's own expert will testify that Deloitte couldn't have found the fraud at TBW because of all the people involved. And the difference is that for Deloitte, they are looking at cash. Pricewaterhouse was looking at mortgages that didn't exist. The cash existed. That was real. So what I understand to be presented with is that don't talk about our audit, blame someone else. And the evidence will show that Pricewaterhouse's own experts are going to say that Deloitte and Touche and actually other people at TBW were not able to discover the fraud because at TBW the cash was real, and because at TBW top-level people were involved, right? Unlike Colonial. Now, I want to be clear that the evidence is going to show that there were thousands of good people at Colonial and TBW, okay? Thousands. Over 2,500 people worked at TBW. 6 of them were fraudsters. The rest were not. And those were good people doing their jobs. And the same thing at Colonial. Thousands of people worked at Colonial that had no involvement in this fraud. We are not casting aspersions on those people. And the evidence, that's what the evidence will show, that Colonial or TBW, the companies, were not indicted. There were thousands of good people working there. So I'm going to prove to you that PwC failed to do its job because you know our big list of Bs? We had a big list of a document when all the fake loans were B, right? Well, we'll show you in Pricewaterhouse work papers how they decided to test those loans. Can we put that up? Oh, here's our B list I'm pointing out to me. So again, this is Pricewaterhouse's own, what they actually did, their official record. And if we look at what Pricewaterhouse actually did, here are all the different customers, and this is we're in the early years, 2004. And in 2004, these are the customers of Colonial that they're doing mortgage business with, okay? And you'll see the biggest one is Taylor, Bean, and Whitaker, TBW. That's our TBW over there. Now, for everyone else, Pricewaterhouse followed the rules. For everyone else, Pricewaterhouse says, right there, we're going to test the individual loans, and we're going to agree it back to the original loan document. We're going to actually look at those hard copy mortgages. But for Taylor, Bean, and Whitaker, Pricewaterhouse had a Plan B. And Plan B for Pricewaterhouse, for Taylor, Bean, and Whitaker, the largest customer, was not to look at the actual loans. We thought down here for the bottom where they said individual loans tested, and we checked that out, and we went to those work papers, but they just compared lists. They didn't look at the actual loans. So for everyone else, we're doing legitimate business, followed the rules and inspected the loans. But for Taylor, Bean, and Whitaker, they had a Plan B. And you could find Plan B because every single mortgage that was not real on the list in 2004, that had a B next to it. Those weren't real. I'm going to prove to you that PwC failed to do its job because PwC followed Plan B for Taylor, Bean, and Whitaker. Instead, I'm sorry, can we put that back up, Keith? Instead, what did they do for Taylor, Bean, and Whitaker, the largest customer? Well, it tells us. PwC confirmed this amount as of 11:30 with Taylor, Bean, with a confirmation. They asked them. The evidence will show that this is 2004. The evidence will show that Pricewaterhouse arranged to have that confirmation sent to Lee Farkas. And the evidence will show that in 2002, Pricewaterhouse was warned that Lee Farkas had been accused of fraud by one of the mortgage government agencies that do mortgages. This is Pricewaterhouse's own work paper. This is Patrick Cox, and he's speaking with Kathy Kissick, the fraudster at Colonial Bank. And what does he write? You see here Fannie Mae. There's several government agencies that buy mortgages and are in the mortgage business. Fannie Mae and Lee Farkas had it out Lee Farkas had bought back the bank from GMAC. Mistakenly, it was packaged and sold to Fannie Mae. Sold all to Fannie Mae to GMAC. Fannie Mae would have to take the servicing if there was fraud. And in fact, after this, Fannie Mae would no longer do business with Mr. Farkas because of the accusation of fraud. Now, Mr. Cox will testify before you that he found comfort in still dealing with Mr. Farkas because LF, Lee Farkas, has taken a lesser role at TBW. But the evidence will show that Mr. Farkas never took a lesser role. And in fact, as part of PwC's Plan B, instead of checking the actual mortgages, they sent an email to Mr. Farkas. This is on our list. Yeah, okay. This is from Mr. Rivers. We saw him before when it was above his pay grade. Mr. Rivers to Lee Farkas, and if we can pull out the rest of that, Keith. I'm sorry, Keith, I think you're going to have to pull out the whole thing for us to be able to see the numbers. Oh, the next document. Okay, sorry, my misunderstanding. Usually, if something goes wrong, it's me, and if something goes right, it's them. All right? So, so this is showing Mr. Rivers asking Mr. Farkas, and Mr. Farkas eventually confirms the millions of dollars. This is Lee Farkas writing back, and if we can just pull out that whole thing, Keith, if we're able to, great. And he sends the email back, and he says, Taylor Bean and Whitaker Mortgage Company Corp. confirms the following balances. If we add up this stuff, it's about $1 billion. And even Mr. Farkas couldn't believe it. He wrote, is this email sufficient? Do you want a hard copy or something? The evidence will show that PricewaterhouseCoopers, instead of inspecting the mortgages, they sent an email. They sent an email to someone who they were told had been accused of fraud and who PricewaterhouseCoopers said was going to take a lesser role, and that gave them comfort, but they're confirming the numbers directly with him. But that wasn't the only part. Because what was supposed to happen in these transactions is Colonial Bank would hold the physical custody, but they were supposed to sell the mortgage on to investors. And one of those investors was a company called Mesereau Financial, supposedly. So mortgage is supposed to go from here to here, and then from here to here. And it would come back and Colonial would hold it, okay? Or a pool of mortgages sometimes. The evidence will show that Pricewaterhouse did recognize this part of the transaction. The evidence will show that Pricewaterhouse was doing an audit of this transaction. The evidence will show that the evidence Pricewaterhouse gathered to say this was real was an unsigned contract. An unsigned contract for fake sales. Now here's one of them. But the evidence will show there were over 1,300 of these for over $21 billion in purported sales between PwC's audit client at Colonial and Mesereau Financial. And the evidence will show that out of the $21 billion in purported sales, 0 were real. 0. And for all of those, Pricewaterhouse relied on an unsigned contract. This was in their own work papers. This is not real. This was not a real transaction. It's unsigned by Mesereau. It was unsigned by Colonial Bank. And the evidence will show that to figure out that all these transactions were fake, Pricewaterhouse needed about 5 minutes. One phone call to Mesereau Financial. One phone call. Because Mesereau didn't even do business with Colonial Bank. And the evidence will show that one phone call could have stopped this fraud. The evidence will show that even Pricewaterhouse's own expert, their fraud expert, said he would make the call. I'm going to prove to you that PwC failed to do its job because it relied on unsigned contracts and just needed one phone call. And as you listen to the evidence as it comes in before you, and you have the opportunity to hear from Pricewaterhouse, please ask yourself, was there any fraudster that prevented Pricewaterhouse from picking up the phone and calling Mesereau? The evidence will show that there was nothing about any collusive fraud. Fraudsters did not cut the phone lines at Pricewaterhouse or steal all their cell phones. The evidence will show that Mesereau Financial was not involved in the fraud. Not. And that could have stopped this fraud. Now, the last thing I'm going to prove to you is that PwC's failure mattered. Pricewaterhouse's failure mattered because people were counting on them to do their job. Pricewaterhouse failure mattered for exactly the reasons that Pricewaterhouse said in its own document. That Pricewaterhouse, can we put that in, was lending credibility to Colonial's financial statements. Pricewaterhouse's failure mattered, the evidence will show, because it was supposed to be independent. It was supposed to add credibility and deliver it to the plaintiff, Taylor, Bean, and Whitaker. PricewaterhouseCoopers' failure mattered because Taylor, Bean, and Whitaker and others relied on Pricewaterhouse to do its job. The evidence will show that at Taylor, Bean, and Whitaker, 99.9% of the people were not involved in any fraud. The evidence will show that each year at Taylor, Bean, and Whitaker, people in the accounting department, the finance department, all waited for PricewaterhouseCoopers to sign its name on its audit report and say that Colonial Bank's financial statements were fairly presented. The why is because Taylor, Bean, and Whitaker couldn't do its job, couldn't do its transactions, any real transactions, without that audit report from PricewaterhouseCoopers. The law required each year for the good people at Taylor, Bean, and Whitaker to certify to the government that Colonial Bank had Pricewaterhouse's audited financials and were clean. Otherwise, these transactions all stopped immediately. So if at any time, the evidence will show, Pricewaterhouse had said, we don't have enough evidence, we're not going to sign our name, everything would have stopped. Because TBW could not conduct its business without PricewaterhouseCoopers certifying the financial statements of Colonial Bank. People in the accounting department at Taylor, Bean, and Whitaker literally pushed a button to certify to the government, okay, we're in compliance, we have the audited financials of Colonial Bank. That was required for them to do these transactions. Taylor, Bean, and Whitaker relied in other ways. At Taylor, Bean, and Whitaker, there were 6 criminals, and the guy that ran the place, he was a criminal. And he had a lot of power. But there were other directors and officers who were not criminals. You're going to get to hear from Jeffrey Cavender. And Jeffrey Cavender was a director and an officer who was not involved. And Mr. Cavender, he is actually the person who forced Mr. Farkas to resign. There were other directors like Stuart Scott, and you'll get to hear these other people who relied. But according to the own fraud expert of Pricewaterhouse, these gentlemen couldn't find the fraud at TBWs. They weren't auditors. Because no one can do the job of a certified public accountant doing an audit except for licensed auditors. The only people that can do it. You have to have a license to do these audits. So someone with an MBA, they can't do an audit because they're not licensed to do it. The FBI can't do financial audits. Colonial couldn't do their own audits. Even judges can't do audits. Only certified, public accountants can do the audits. Taylor, Bean, and Whitaker was justified and did rely on people in its accounting department, its finance departments, and directors who were not involved in the fraud and officers who were not involved in the fraud. And that reliance, PwC's failure, mattered. And to understand that, let me just explain a little more about how we got here with Mr. Luria. Mr. Luria, he was called in when the fraud was discovered. The fraud was discovered in August of 2009. The FBI raided Colonial Bank and at the same time raided TBW. And the government stepped in and issued a cease and desist order. Nothing else could happen. Jeffrey Cavender reached out ultimately to Mr. Luria's firm. Mr. Luria, the evidence will show, has been appointed by bankruptcy trustees and has extensive experience in this area. Mr. Luria came, and what he found at Taylor, Bean, and Whitaker was people's house payments stacking up. Because since the bank accounts at Colonial have been frozen, Taylor, Bean couldn't forward along people's house payments. The evidence will show that Mr. Luria, he unraveled that mess. That Mr. Luria got those people's house payments paid. But more importantly, what it will show is that Mr. Luria has worked since that day until we hear today to recover for the people who were harmed. Mr. Luria, when he got there, he first didn't have any power. But after Mr. Cavender forced Mr. Farkas to resign, the United States Department of Treasury, Office of Thrift Supervision, they issued that cease and desist order, and then they cleared and approved Mr. Luria to take over Taylor, Bean, and Whitaker. All the directors resigned, and Mr. Luria, the evidence will show, approved by the Department of Treasury, along with 2 independent brand new directors, came in. Mr. Luria, the evidence will show, then put TBW under the protection of the bankruptcy court, and the bankruptcy court then reappointed Mr. Luria as the chief restructuring officer, like the head of TBW. Mr. Luria then worked with the government to help put people in jail, and he worked to recover money for the people who had been harmed. And ultimately, the bankruptcy court created the Taylor, Bean, and Whitaker Plan Trust. That's the plaintiff here today. And the Taylor, Bean, and Whitaker Plan Trust was created for creditors or beneficiaries, people who lost money. These are individuals and businesses. These individuals and businesses, these are real money that was lost that are represented by Mr. Luria in this courtroom today. And this is also important. The evidence will show that these creditors and beneficiaries, people that lost real money that Mr. Luria represents, these do not include the convicted criminals. Okay, they are not part of what Mr. Luria represents. And the convicted criminals will not receive any money from this case. Mr. Luria represents the people that were harmed. And those include the FDIC took over Colonial Bank, and the largest creditor beneficiary is, in fact, Colonial Bank. That for the plaintiff plan trust, the largest creditor beneficiary that Mr. Luria represents is Colonial Bank. And in this transaction, Colonial Bank lost $2.2 billion, real money. The next is Ocala Funding, which was a subsidiary of TBW. And in these transactions, that for 7 years, Pricewaterhouse signed their name to assets that didn't exist. Ocala Funding lost $1.7 billion. Freddie Mac and Ginnie Mae, those are government, arms of the government that do this mortgage stuff. And in transactions, these transactions, the assets that didn't exist, Freddie Mac and Ginnie Mae lost $1.22 billion and 610, I think at 0.610, that's 610 million. Right? And those are the largest creditors and beneficiaries that Mr. Luria seeks to recover for in this case before you today. He does not represent any criminals. They're excluded. He represents only the people who were harmed. PricewaterhouseCoopers' failure mattered. I guess we rounded down because $5.5 billion was lost when PricewaterhouseCoopers signed its name to financial statements for the assets that didn't exist year after year for 7 years. It's a big case, and it took me a little while. Y'all didn't, I appreciate the time you spent listening to me. So, what I told you I was going to prove, you hold me to it. Not a politician, not somewhere else. I know it's election season. I'm going to go off to Tallahassee. I'm actually going to come back before you when all the evidence is in. So what I told you I was going to prove, you hold me to it. Put up Pricewaterhouse. Because when you sign your name to something, it matters. And when you're a professional auditing a public company, it matters. And when you don't do your job and real people get hurt, it matters. So you hold me to it. When I come back. Thank you.
Are you yielding?
I'm yielding, Your Honor.